for example, did not appeal the decision but are seeking to correct. And as you noted, put the word knowledge back into the legislation.
All right, we have Senator Denise Batters. She was in some hot water for some heavy speech that, beyond us, but she's an all-star nonetheless. Firebrand kind of politician. Check this out.
The Vice Chair of the committee, Senator Batters.
Thank you very much. Minister Leblanc, prior to amendments made by your government to the Canada Elections Act in 2018 and Bill C-76, the word knowingly was in the Act. When Conservative MPs opposed removing the word knowingly and tried twice to reinsert this word into Bill C-76, your majority government blocked those efforts. Your government now claims that the word knowingly was removed as a housekeeping measure. In her judgment on this matter, Justice Davies said this in referring to advice given by a senior Privy Council office official, Mr. Jean-François Morin, to the House of Commons Procedure and House Affairs Committee during their clause-by-clause deliberations on those Conservative amendments to Bill C-76, quote, "More importantly, the advice given to the Standing Committee by Mr. Morin that the inclusion of the word knowingly in Section 91(1) was unnecessary, redundant, and confusing was for several reasons incorrect and potentially misleading, quote." And the judge went on to list all the reasons why. Minister, it is startling to see a judge so strongly criticize advice given by a senior departmental official to a parliamentary committee considering a bill. You were the president of the Queen's Privy Council for Canada when this case was argued in that court last fall and when this scathing judgment was rendered in February. What actions did you take in that department, if any, once you saw this judgment detailing the faulty advice your official gave to a parliamentary committee?
Madam Chair, through you to Senator Batters, obviously senior public servants that are invited regularly to appear before committees of your chamber or in the House of Commons give to the best of their ability and knowledge the advice and the information that they have. We also respect that a judge in a court case before the particular court, in this case the Superior Court of Ontario, can hold a different view. We respect the court's finding, and that's why we, for example, did not appeal the decision but are seeking to correct. And as you noted, put the word knowledge back into the legislation. At the time, we believed, in good faith, obviously, at the time Bill C-76 was passed, that it would be a sort of a technical amendment clearing that up. The court had a different view. We are happy to respect the court's opinion and to act accordingly. Perhaps, I don't know if Al Sutherland or Manon would like to add something, but in our view, the advice tendered at the time was valid. The court had a different position, and we're proceeding to respond to the court's decision.
Minister, I think you've answered it very well. I have nothing to add.
I would just say, Minister, that this went beyond a difference of opinion or a different viewpoint, and it impacted the decision such that the judge said, after a careful consideration of the amendments in the context of that Canada Elections Act as a whole, I am left with only one plausible interpretation that Parliament intended the removal of the word knowing from 91(1) to reflect a substantive change to the prohibition and offence. So that type of advice, I just want to let you know, Minister, can have a dramatic impact, and that can even lead to a particular assumption by a judge on parliamentary intent. So I'm assuming from your answer that you didn't take any steps dealing with your department, but I just asked you to consider that. Thank you.
Thank you, Senator Batters. We will now go on to...
For example, did not appeal the decision but are seeking to correct. And as you noted, put the word knowledge back into the legislation.
On Division 37 of Part 4 of the Budget Bill, which deals, as you know, Senators, with elections. The Minister is accompanied by the following staff: Alan Sutherland, Assistant Secretary to the Cabinet; Manon Paquette, Director Special Projects, Democratic Institutions, Secretariat. Minister, before we proceed, I would like to introduce you to the members of the committee, and they are Deputy Chair Senator Batters, Deputy Chair Senator Campbell, Senator Boisvenu, Senator Boniface, Senator Carignan, Senator Cotter, Senator Dalphon, Senator Dupuis, Senator Pates, Senator Simons, Senator Tanner, and Senator Gold. Minister, the floor is yours. Thank you.
Well, Madam Chair, thank you. Honorable Senators, thank you for the privilege of appearing before you. Madam Chair, perhaps you'll allow me a few personal comments at the beginning. It's a pleasure to see you, even if virtually. We've known each other for over 20 years. I was thinking about that this morning. I've long admired your work in the upper chamber, particularly with respect to human rights. And I was looking at the membership of your committee, and it's an impressive and intimidating group of senators. I'm glad that David Lametti appeared before me, so any complicated technical legal questions coming from the senators with such a vast array of legal and constitutional scholarship were properly posed to my colleague David Lametti. But I'm very much looking forward to this exchange, and I thank you for this invitation. Honorable Senators, as your Honorable Chair said, I am here to discuss obviously any issue that you think I may be able to discuss, but in particular, Part 4, Division 37 of Bill C-30, and as your Honorable Chair said, it refers specifically with respect to provisions of the Canada Elections Act. Your Chair introduced my colleagues from the Privy Council office, who are also with me there in Ottawa. I'm speaking to you from Moncton, New Brunswick this afternoon, but obviously they'll be happy if there are questions that their expertise perhaps can better answer. I would obviously be happy for them to do so as well. This particular portion, Honourable Senators, of Bill C-30 proposes amendments to the Canada Elections Act to clarify that the provision that prohibits false statements about certain political actors requires knowledge that the statement is false. This provision prohibits making or publishing false statements about certain political actors to affect the results of elections. This includes, amongst others, claims that such actors have committed a crime or claims about their citizenship, place of birth, or education, to cite a few examples.
As many of you are well aware, on February 19th, 2021, the Superior Court of Justice of Ontario found that this provision of the Canada Elections Act is unconstitutional and without effect in Ontario. The court determined that even if the provision requires proof of the intention of influencing the results of an election, it does not require knowledge that the statement itself is false. Our government did not appeal the decision of the court because we believe that a targeted amendment that deals directly with the concerns of the court is preferable.
Amendment would address the court decision by explicitly requiring that an individual or entity making or publishing the false statement knew it to be false. It would do so by adding the word knowingly to the two offense provisions associated with Section 91. It's important to note that in its direction, the court recognized the importance of addressing the growing threat of disinformation. Federal elections are important opportunities for all Canadians to be heard and obviously to express their opinions by casting a ballot. At the same time, the participation of electors and others, including registered third parties, for example, should come with clear rules and responsibilities. These include, for example, spending limits and prohibition on the use of foreign funds by third parties. With this amendment, these rules extend to protecting against deliberately false information intended to affect election results, which can have a devastating impact on trust in our democratic institutions. In particular, it would guard against those individuals and entities that spread blatant falsehoods about political actors to affect election results, which often have a disproportionately negative impact on women, racialized individuals, Indigenous peoples, amongst other traditionally underrepresented groups.
Furthermore, the Commissioner of Canada Elections, the independent agent responsible for compliance and enforcement of the electoral legislation, revealed in his annual report of 2018-2019 that a certain number of complaints received during the 43rd general election were connected with the provision on false statements. This demonstrates that Canadian voters and candidates, among others, are deeply concerned by this issue. Honourable Senators, this amendment is also important on account of the role played by this provision to protect against flagrant falsehoods, and in the case of our broader efforts as a government and as a society to fight against disinformation.
Such, Madam Chair, I will conclude my remarks by highlighting briefly some of the important work the Government of Canada is conducting to address the growing and evolving threat of disinformation. For example, the Department of Canadian Heritage's investments in the Digital Citizens Initiative aim to strengthen citizen resilience and recognition that Canadians are the best line of defense in our collective effort to fight disinformation. Additionally, we recently published Multi-Stakeholder Insights, a compendium on countering election interference, which represents the culmination of the Government of Canada's co-leadership alongside Microsoft and the Alliance for Securing Democracy in Principle 3 of the Paris Call for Trust and Security in Cyberspace. And I recently released, Madam Chair, this work with the president of Microsoft, Brad Smith, and the German Marshall Fund. The compendium was developed following a series of 6 workshops that were delivered in collaboration with international partners and experts from government, industry, and civil society, and which aimed to share key observations and further the global understanding of ways to counter cyber election interference. These partnerships and initiatives taken with the proposed targeted amendments to the Canada Elections Act help Canada stay at the forefront of new developments in understanding and responding to this evolving threat environment. So once again, Madam Chair, thank you for the opportunity.
And of course, it will be a pleasure for me to answer your questions.
For example, did not appeal the decision, but are seeking to correct. And as you noted, put the word knowledge back into the legislation.